With respect to...
Let's just say hypothetically, though. Hypothetically. And I know I'm going to get...
I know all the usual caveats, and I accept them.
Thank you, Mr. Waxman.
I'm pretty sure since you're asking me, I'm not going to like...
You're not going to like it. But let's assume that a very wealthy university could pay for everybody to go and still increase its endowment. It's a perpetual motion machine, Malcolm Gladwell called them. Let's say if it just gave up preferences for donors' children, legacies, and squash athletes, okay? Or maybe those who row crew, all of which tend to favor predominantly white children. And it could achieve whatever it deemed racial diversity. Would it then be permitted to engage in race consciousness, or in that circumstance, would you agree that that would not be narrowly tailored?
So I'm not claiming, I'm accepting your hypothetical as hard as it is for me in light of what the evidence shows.
There we go.
I am not claiming that there is a compelling interest in having donors per se. There is a compelling interest in your proverbial art museum. There is a compelling...
There is a compelling interest in the art museum?
No. These are the things that I'm not claiming.
Okay.
I'm just claiming all of those things.
All right.
When you look at a so-called race-neutral alternative, the question that this court, that Justice Powell articulated in Bakke and this court underscored and amplified in Grutter and then in Fisher is does that race-neutral alternative actually substantially impact the character of the institution and the education that's being provided?
Now, let me stop you there, because, and I'm sorry to interrupt, but surely getting rid of those preferences would substantially impact the university. But you're saying they are not a compelling interest for constitutional purposes.
So no, what I'm saying...
Or does the 14th Amendment make legacy children...
Of course...
Okay, no, so we agree.
Of course not. And the truth of the matter is that if this were a case in which the evidence showed that eliminating a legacy preference made a substantial difference, the district judge to say that the district judge was applying strict skeptical scrutiny on the narrow tailoring principles is quite an understatement.
Okay.
Might have decided otherwise. What the district court found, and Judge Gorsuch, if I can just make one comment about the record, which I think responds to at least the gist and spirit of your hypothetical. With respect to race-neutral alternatives, the simulation, what has come to be called Simulation D in this court, the district court found that, quote, the Simulation D would require, quote, sacrifices on almost every dimension important to Harvard's admissions process. Among other things, and these are all recited in the Smith Committee report, they are recited in the extensive discussion of race-neutral alternatives in both the district court opinion and the Court of Appeals opinion, are that, for example, with respect to academic excellence, the academic factor, the number of matriculants who score 1 or 2 on the 5-point scale would go down 17%.
I'm familiar, Mr. Waxman, I am familiar with all of that. Along
so in other words,
we go down from 99 to 98th percentile. I've got it. If I might shift gears, okay. I'm familiar with all those, and I appreciate that, and I understand your point. It was a hypothetical. What do we do about history here? Because one thing we know, or we think we know, or we're told in the briefs at least, is that Harvard's move to a holistic application approach happened in the 1920s because it wanted to impose a quota on Jewish applicants, but it didn't want to do through front door. So it used diversity as subterfuge for racial quotas.
What the record in this case shows, and it's discussed in some detail in the, I'm going to blank on the names of the reports, but the various reports that Harvard has done over the years on diversity and diverse admissions in the case. One is the so-called Rudenstein report, and the other is the Khorana report, both of which are in the joint appendix, is that Harvard actually, even before the Civil War, has as its admissions policy an effort to, in fact, diversify on both viewpoint and geography the class. Now, there's no doubt, and Harvard acknowledges and is ashamed that in 1920, one of its presidents, President Lowell, decided that there were too many Jews and that they were then going to start asking questions on the application that would allow them to take into effect character. The notion that that bears at all on the way that Harvard's current admissions process, which uses a 40-person admissions committee that meets and decides each application en banc in discussion, has any resemblance whatsoever to the racist, anti-Semitic policy of a single Harvard president is insubstantial, as the courts found.
Okay, how do you respond then to, again, we have many briefs on this point from Asian American applicants who have, and they say there's an entire industry to help them appear less Asian on their college applications, and that they consider elite colleges to have Asian quotas effectively, if not in name?
I'll say two things. One, generally about the amicus briefs, and two, specifically about Harvard. And I certainly want to get to number two. But there are multiple amicus briefs filed by Asian American organizations, and one that is particularly, I think, powerful, filed by 1,240 scholars of Asian American experience and Asian ethnicity, all of whom not only opine, but cite studies showing that Asian Americans as a group, and Asia, of course, represents 61% of the world's population and a multiplicity of ethnicities, that Asian Americans demonstrably benefit from a holistic admissions policy that considers race as one factor among many. Now, with respect to Harvard, to say that there was evidence in this case is quite an understatement. The district court found, I'm quoting page 261 of the joint appendix, and it's reiterated by the Court of Appeals on page 80 of the joint appendix, that there was, quote, no evidence of discrimination against Asian Americans whatsoever. Again, now on page 264, there was consistent, unambiguous, and convincing testimony that there was no discrimination in the admissions process in general and the personal rating in particular. The plaintiffs in this case could not, after 4 years of discovery in which they hand-picked applications to view in total, they could not produce a single witness to testify that he or she had been discriminated against.